Welcome to the Business Scholarship Podcast, a place for interdisciplinary conversations in the broad world of business research. My name is Andrew Jennings, and it's my pleasure to be your host. If you like what you hear today, please subscribe to the podcast on Apple, Spotify, or wherever you get your podcasts. Plus, leave a rating and let other people know about the show too. And if you have ideas for the show, please let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. All right, time for the episode. Our guest today is Nicole Iannarone, Associate Professor of Law at Drexel University. We'll be discussing her new article, Small Claim Securities Arbitration, which is forthcoming in the University of Pennsylvania Journal of Business Law. I'll add a link to the article in the show notes for the episode. Nicole, welcome to the Business Scholarship Podcast.
Thanks, Andrew. I'm excited to chat with you today.
I'm excited to chat with you as well, both about this paper and some of the additional topics that spin off from the paper that we'll touch on toward the end of the episode. Nicole, when I teach securities regulation, I like to challenge students to think about just who is an investor, who is the person who is receiving the protections of the securities laws. What are their demographics? Are they a person? Are they a non-human entity? Are they a corporation or some fund? What sort of wealth do they have? What sort of goals do they have for their investments? Because there just isn't one kind of investor. And so the way the securities laws protect them or the way the securities laws don't protect them will differ from investor to investor. Who is the investor at the heart of this paper, Small Claim Securities Arbitration?
The investor at the heart of this paper is the average American, and the average American who has a little bit of savings, who has done the things that experts say they should do. They save for retirement. They recognize that while they're good at their own line of business, they need a little bit of help in navigating what they should do with the money that they put away in their nest egg. And they're typically someone with less than $25,000 in investing assets, which is a lot of money for them and can make a big difference for their lives should that money not be available when they need it. Like most Americans, they don't have a great deal of financial knowledge. It's pretty well known in this country that our financial literacy isn't great. And that's exactly why they're reaching out for help. And the help that they're seeking is with a stockbroker.
Can you tell me a little bit about the role of the stockbroker in helping those average Americans with some savings, but potentially in the grand scheme of things, modest savings that are investable for them? What's the role of the stockbroker in helping them navigate the process of, or hopefully turning those savings into a larger sum for retirement or whatever their financial goals might be? And are there any risks that are inherent in that relationship between the smaller retail investor and the stockbroker whom he or she is relying upon for some of this help?
Retail investors, the folks that I'm concerned about in this paper with more modest investments, tend to really trust the stockbroker that they're working with. I use a line that my husband shares with me all the time. If I'm paying somebody to give me advice, I'm going to do what they tell me to do. The nature of the trust relationship, I found, is really quite strong. You'll hear stories about my stockbroker isn't just somebody who's giving me advice. They're my friend. I know them from church. I have a couple of beers with them. So these investors listen to the advice that they're getting. And many times when investments are recommended for them, they might not know questions to ask or be embarrassed to ask certain questions with the assumption that the stockbroker is going to be making a decision for them that's at the interest of the investor and will be best. So yeah, there's risks involved in any kind of relationship. In this type of relationship, sometimes things don't turn out the way they're supposed to. Sometimes stockbrokers make mistakes. Sometimes they engage in misconduct. And one of the risks that an investor can face as a result of that is they've got to figure out when something goes wrong, how can I recover? How can I rebuild my nest egg? The securities world is really interesting because investors who work with stockbrokers are pretty much entirely required to arbitrate any claims that they have before FINRA, Financial Industry Regulatory Authority. And this arbitration process, while inexpensive to use compared to some of the other major arbitration providers out there, isn't always easy to navigate. If you are an investor who has a smaller loss under $100,000, it can be really difficult, if not impossible, to find an attorney to represent. I worry that one of the biggest risks that retail investors, regular investors have when they seek stockbroker help is that they are in a position where if they don't lose millions of dollars or hundreds of thousands of dollars, that although a system exists to help them get that money back, they might effectively be barred from using it.
One of the realities of litigating small claims is that often it's economically infeasible, but we do have in the United States this mechanism of the class action. Is that a potential solution for smaller retail investors who are harmed by mistakes or misconduct that their stockbrokers might engage in?
Class actions are used in some circumstances to allow Americans or anyone with similar claims to aggregate them and recover. They aren't used in the FINRA forum. There is not a mechanism to have a class-wide arbitration. Now, the difficulty also arises in having class actions as a potential solution for this problem because there are so many individual issues related to a person's decision to invest, such that I think those issues are going to predominate in all but a very small group of product failure cases, such that you're not going to get a class certified. And we've got this whole range of claims, smaller ones, that are going to be difficult for an investor to recover on. And I think that's a really big problem because one of the reasons we have securities arbitration in the first place is because before there was even a regime in this country for securities laws, we realized that unless people putting money into this intangible stock market have a realistic ability to recover and hold someone accountable when something goes wrong, why would they trust the markets? There is this entire trust and legitimacy function of arbitration that I think is really undermined when we don't allow smaller investors a realistic way to go back and become whole when something has gone wrong. And although the class action device is a possibility, I just don't think that it could work in most of the types of claims that we see in the securities stockbroker versus investor world.
With that really helpful background in mind, I wondered if you could introduce the research questions that motivate this paper and perhaps where this paper fits into the existing literature that you're drawing from.
What motivates this article is something that was a little bit of a pet peeve of mine. I've known through my own work with investors with smaller claims that it's really hard for them to find an attorney. I still get calls and emails from people who believe they have a situation and are at their wits' end because they keep hearing that their case is too small and there isn't anyone who's able to economically assist them. Now, Others had said to me when I repeat what I thought was true, that you're going to have a hard time finding a lawyer unless you've lost at least $100,000. The response to that was, this is just anecdotal. And I thought, there's a way to take a look at this. There's a great deal of literature that looks into FINRA arbitration. And the reason it does so is because FINRA arbitration awards are all public. They're not public in the same way that a court opinion is public, but we do have some baseline information about every decision made by an arbitrator in a case. We don't have an explanation for why an arbitrator ruled as they did. FINRA arbitrators aren't required to explain their rationale. But we do know something about each of the investors. We know how much they were seeking, a general description of the claim they filed, who their representatives are, if any. We know a lot about location of claims. And as a result of all of this public information, there are several folks who have tried to learn about what is going on in the forum. What's happening in all of securities arbitration? I should pause here to say, by the way, there are two different types of securities arbitration. One is stockbroker versus stockbroker, industry side. Firms who have disputes with one of their registered representatives. There's also the customer side of arbitration. So there's a great deal of research looking into both the industry side, employment claims, other disputes, and the customer side. Now, I focus specifically on the customer side, and I wanted to know if there's something different that's happening with smaller claims. So in the roundabout way of answering your question, where does this paper fit into the existing literature on customer claims? It fits in by looking at the question a little differently. Are there differences in outcomes based on the size of a claim and really who the investor is? Is it a claim that's associated more with an average American's investment account, or is it a larger claim?
So we have the benefit of this great transparency compared to other arbitral fora with FINRA arbitration in terms of the awards being public, available to members of the public, available to scholars such as yourself. And you really leverage that openness for this paper. I wondered if you could talk a little bit about the empirical strategy. What sort of data were you able to find in those awards and how they might have allowed you to tackle some of these research questions?
The empirical strategy for this paper was fairly straightforward. Because we have all of this transparency in FINRA arbitration, I went first to the FINRA Arbitration Awards online database, scraped the files for my period that I was interested in looking at. And that's the 5 years preceding the pandemic. As we all know, some strange things happened in courts and any other dispute resolution forum in 2020. I thought that might skew what's happening in arbitration awards, and I excluded that information. But a little footnote there that I might take a look at it in the future because we could see some interesting things there as well. So once I narrowed down my data set to a period of time immediately preceding the pandemic, I looked at every award that related to a customer, investor versus stockbroker case and divided them across many different lines of analysis or categorization, I should say. Some of it was done by machine. All of it was checked by hand. I have read a great deal of arbitration awards, and with the help of an intrepid team of research assistants, know a lot about what's happening in each of them. For the purposes of this paper, the hand coding we did, things that mattered the most were how much or Does the investor think they suffered? We quantified that monetarily. We also looked at, because the awards in the FINRA database tell us this, who represented the investor. And we classified representation type by either attorney. So we had to do a little bit of research sometimes to figure out if the stated representative for an investor was an attorney or not. We also looked for non-attorney representatives, which until January were allowed in certain circumstances to represent investors and charge for their work. And then we looked to see if folks were representing themselves or perhaps had sought the assistance of a law school securities arbitration clinic, of which there are a few left in this country. That divided the awards really by size of claim into some buckets. FINRA arbitration has some very useful procedures that made that a little bit easier. Larger claims are typically $100,000 or more. So I used a dividing line there. That's a number at which you'll have 3 arbitrators instead of 1. And then within $100,000 and less, there's another category called simplified arbitration. And that is for claims that are much smaller, $50,000 or less. And within that claim category, investors have a number of options for going forward. So I thought it would be interesting to see what differences that we might have based on claim size and whether or not an investor recovered anything at the end of their case. My metric for win is the same one that FINRA uses, and that is, did they recover more than $1? There are a lot of problems with that as a potential metric, so much so that I have an entire law review article about why this measure may not accurately classify a win. Nevertheless, since prior research has looked at awards in such a way, I use that metric so that we can compare to FINRA results and findings that were made by others. And then I just did some very basic statistical analyses to see if there's association between various factors. Is there an association between claim size and whether an investor is represented? And is there an association between representation and recovery? Also found a couple of other interesting things related to some of the other lines that we have coded within the arbitration awards.
In pulling together and scraping these data and conducting these analyses with the assistance of some of your intrepid RAs, what were some of your key findings? What were some of the answers for your research questions? And are there any potential mechanisms that you'd like to raise for those findings?
So the findings for me validated what I thought I knew already. And that is that if you have a bigger claim and your award is decided by an arbitrator, you're much more likely to be represented. So 80% of investors with claims over $100,000 whose case was decided by an arbitrator have a lawyer. When I look at claims below $100,000, it's less than 50% of investors. When I look at the smallest cases, those that fall in that simplified category, only 52% of investors have some type of representation. Now, there's also another unsurprising finding, and that is that if you have a lawyer, you're more likely to obtain some monetary recovery. Investors with the larger claims, over $100,000, win $1 or more in 44% of cases. Now, when we look at the smallest claims in the forum, pro se litigants seem to have a harder time. They recover in only 24% of cases that are decided by an award. Now, there are obviously a lot of limitations with this research, selection effect being a huge one. Attorneys are probably better at filtering out claims that shouldn't be filed in the first place. Maybe the best claims are being settled. There's a lot that we don't know. But what we have found is that there are significant associations between claim size and representation and recovery. Also, somewhat surprisingly to me, I found an association between the time it takes for an award to be issued from filing to award. There's a longer time to get a ruling when an attorney is involved in a smaller claims case. And I can't tell you why that is, but my thought as to why it is that there isn't an automatic mechanism for discovery in simplified claims. And I think that investors representing themselves in the forum may not be aware that discovery is available to them and may not be obtaining documents that could help them better present their case.
Are there any open questions that you have from this study, or has this study perhaps generated new questions that you might want to tackle in the future?
Yes, there are many open questions. And some of the ones I'm tackling now are, what do we do about this? If we have a problem here that regular people, when they do what they're told and they get someone to help them and they have a problem, have difficulty finding an attorney and have difficulty going it alone in this forum, what should we do about that? So right now I'm working on a piece exploring the normative implications of the empirical findings. And I think we can consider two potential mechanisms or two buckets of mechanisms. And one is, I would call the gold standard. Let's get attorneys for everybody. Obviously, a much more expensive proposed solution, but there are some means to get us there. And one I think that's important is trying to expand the network of law school clinics where students learn while helping others who weren't going to otherwise be able to afford counsel. And the other bucket is, what about non-lawyer alternatives? Are there any procedural irregularities in this forum that make it difficult to achieve what was this goal of securities arbitration in the first place? Or an investor to, simply by filing a single page letter, get recovery when something went wrong without the need of an attorney? And I think there are some issues with how we currently arbitrate that are impacting the ability to reach that goal. So stay tuned for that one.
All right. So we'll have to keep our eyes out for some of this forthcoming work to resolve perhaps some of these open questions. Nicole, I'd like to switch gears a little bit from this paper to maybe the broader world of securities arbitration that you introduced for us. You're both a scholar of securities law and securities arbitration, and you have a lot of direct experience in this area in really multiple capacities. Could you tell us a little bit about your work in this area and how it has informed your scholarship?
When I first entered legal academia, I did so coming from a long practice background. And the first role I had on a full-time basis was starting up a law school clinic that helped regular folks try and recover in this forum. So I've seen a lot of regular people who are not worried. I trusted somebody and they lost my money and nobody is out there to help me. And that is a huge impact on their lives. We heard so many stories from them. These are their words, not mine, about how the loss of money impacts them. The one that sticks me the most is, As a result of this loss, I have to choose between 1 month buying dog food or toilet paper. Other investors were making decisions about whether to pay for their rent or purchase medications. So although it seems like we have a group of people who were rich enough to invest in the first place, why should we care? The ability to help them is often what stands between them and other types of really limited social service in this country. So my experience in working with the investors and working with law students who are representing them has really driven me to focus on this particular research. Now, at the same time, Andrew, you mentioned how we've got a lot of transparency in the FINRA forum. One of the ways it is, I think, transparent and a benefit of the forum is that it involves a lot of experts, practitioners, those who have knowledge about what's going on. So one of the things I do in addition to having represented investors and worked with people navigate this process is I chair a group within FINRA called the National Arbitration and Mediation Committee. And our role is to give FINRA advice about what's working, not working in the FINRA forum, and help them as they consider making procedural changes. So I'm one of the public members of the arbitral forum, and we like to think about things like, say, do we need to change discovery rules? Do we need to help out these investors who may not know if they're going it alone, that they can get discovery? Can we make it easier for them to go forward? A shorter version of answering your question is my work in this area comes from working directly with investors who have been harmed, who have had smaller claims and difficulty, engaging with the individuals who run the arbitral forum and giving them feedback through a formal committee process, and both alone and with students, evaluating and commenting on proposed regulation that impacts the forum. That experience and work directly informs my scholarship. I very much recognize that the findings I have in this article, they're not surprising to me. And many other readers are probably thinking, yeah, I'd assume that someone's going to do better when they have a lawyer. And I would assume that someone is less likely to find a lawyer if they have a smaller claim. I think there's something really important about putting some heft behind what we think is happening so that we can really think about how to make changes to include those who are otherwise left out of the process.
We've talked about the process of FINRA arbitration at a fairly high level. It's an arbitral forum located within FINRA. I wonder if we could drill down a little bit about just who's making these arbitration decisions, who's issuing the awards or not issuing the awards to claimants. Who are the arbitrators who serve on these FINRA panels? Are they retired judges, partners at law firms? Are they employees of FINRA? Are they all located in big financial centers like New York and Chicago and San Francisco? Just who are the folks behind the scenes who are making these decisions on claims submitted by either customers or even intra-industry claims that might be submitted?
Arbitrators are a wide group of people who have all varied experiences across the country. They are not FINRA employees. They are independent contractors. I am an arbitrator on the roster. I've never been selected for a case. At some point, I might be. So there are, of course, lawyers on the roster. I don't have recent numbers on this, but the last time I've seen FINRA report on it, about 50% of the arbitration roster is an attorney. The qualifications to serve as an arbitrator are simply that someone have at least 5 years of business experience of some type. And that's pretty broadly construed. So I would say every law professor I know, whether they have securities experience or not, is qualified to serve as an arbitrator. There's a particular problem and lack of arbitrators in places that are not the big financial centers that you mentioned. So in the middle of the country, where we might have a lot of other law schools, we have a need for people who are interested in serving to become arbitrators. It's a pretty straightforward process. Fill out an application and, assuming the qualifications are met, take an online training. That's it. I think it's important to have a wider range of arbitrators available. You don't need to be a securities law expert. And in fact, to serve on customer disputes, being a public arbitrator, not having an association with the securities industry is one of the characteristics that we're looking for. So I would urge everyone who's listening to consider signing up to be an arbitrator, particularly if they are not in a major city.
Our guest today has been Nicole Iannarone, Associate Professor of Law at Drexel University. We've discussed her new article, Small Claims Securities Arbitration, which is forthcoming in the University of Pennsylvania Journal of Business Law. I'll add a link to the article in the show notes. And as Nicole talked about, the opportunities for professors, lawyers, or other listeners of podcasts to join the FINRA arbitration panel, I'll include a link where you can find more information about how to do that. Nicole, thank you for joining the Business Scholarship Podcast.
Thank you, Andrew. I've enjoyed talking today.
Thank you for listening to another episode of the Business Scholarship Podcast. If you like what you heard today, be sure to subscribe to the podcast on Apple, Spotify, or wherever you get your podcasts, rate the show, and let other people know about it too. If you have ideas for future episodes, let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. Until the next time, I'm your host, Andrew Jennings.